Another big ruling by the United States Supreme Court moments ago, a 6-3 decision authored by Justice Amy Coney Barrett in Murphy versus Missouri. Let's take a look at what Justice Barrett said, what this case was about. During the 2020 election season and the COVID-19 pandemic, social media platforms frequently removed, demoted, or fact-checked posts containing allegedly false or misleading information. At the same time, federal officials concerned about the spread of misinformation on social media communicated extensively with platforms about their content moderation efforts. The plaintiffs, 2 states and 5 social media users, sued dozens of executive branch officials and agencies, alleging that they pressured the platforms to suppress protected speech in violation of the First Amendment. In other words, these right-wing led states and these users said that they wanted to spread their COVID disinformation, and they did not want to be fact-checked at all by the Biden administration. The Fifth Circuit, the far right-wing Fifth Circuit, agreed with the states and the lawsuits that were brought by the right-wing states, concluding that the Biden officials' communications rendered them responsible for the private platform's moderation decisions. It then affirmed a sweeping preliminary injunction. The Supreme Court now says the Fifth Circuit was wrong to do so, and they ruled on the grounds of standing that there was no standing at all. To establish standing, plaintiffs must establish a substantial risk that in the near future they will suffer an injury that is traceable to a government defendant and redressable by the injunction they seek. No plaintiff has carried this burden, and they do not have standing. Let's bring in Mike Sachs from Court Accountability, who's also our law and politics correspondent and an expert on the Supreme Court. Mike, what do you make of this decision?
Yeah, Ben, thanks for having me. So this decision is a 6-3 decision with the court's Republican-appointed power center of Chief Justice Roberts, Brett Kavanaugh, and Amy Coney Barrett, all joining the 3 Democratic appointees, which is Justice Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, in saying that the plaintiffs here, the Republican states, as well as the 5 social media users who were claiming that they were deplatformed or censored by the Biden administration's jawboning of Facebook, that they do not have standing to sue, meaning they cannot trace whatever injury they claim to the actions of the government. Ultimately, standing doctrine here is a way for a court to avoid the merits of a case they'd rather not touch. But in this case specifically, it was pretty clear that these plaintiffs simply did not have standing, and they were trying to get around something that Facebook should have sued if they actually wanted to sue. But Facebook, they didn't seem to really care that the Biden administration was helping them police misinformation and disinformation about COVID vaccines and COVID itself on Facebook's platform. There's a huge record of evidence brought forth by the plaintiffs in this case showing that the Biden administration's jawboning of Facebook bordered on a bit aggressive. But as Justice Brett Kavanaugh, a former executive official in the Bush administration, said in oral argument, that's something that government officials do all the time to private entities when they want to explain their views on something as a matter of policy. It was not coercive. It was not trying to make Facebook do as we say, otherwise Facebook will be regulated out of existence. But rather, it was an attempt to guide policy and make sure that misinformation did not flourish on these huge social media platforms that are widely influential. Now, everything I just said there, those are merits determinations. That's whether there was a First Amendment violation in this case. But the Supreme Court avoided that altogether. The Supreme Court, the 6 justices in the majority, said that, simply put, the plaintiffs in this case were not Facebook. They were not directly injured by the Biden administration's jawboning. It's the officials jawboning Facebook. They did not have a direct enough connection to that jawboning to establish that that the plaintiffs could go into court and say, we got injured by this. Too attenuated. So that's ultimately what this decision said. But I want to zoom further out and draw attention to what this means in the context of this court's term. This case came out of the Fifth Circuit. The Fifth Circuit is quite right-wing. It's a YOLO MAGA court, really. And this Supreme Court is also quite right-wing. But it wants to present itself, after a couple of terms of being very aggressive, wants to present itself to the public as a little more moderate, as a court that isn't trying to just effectuate the entire Republican Party policy preferences. And this case, among several others, were teed up to it from the Fifth Circuit, which was trying to effectuate the Republican Party's policy preferences, for the Supreme Court to say, no, we're not those guys. Those guys are nuts. You can trust us to do things even-handedly and apolitically. Of course, that is not what this Supreme Court does either. You can point to a whole bunch of other cases on this term's docket. Rather, this term and this case and these Fifth Circuit cases are meant to balance out the other cases this term in which the court has reached out to decide cases that do further the right-wing legal movement's agenda. The agenda of those who have funded this litigation going forward to them, the agenda of those who have funded the campaigns to get at least the 3 of the Trump justices put on the court itself, and the agenda of those who have largely, frankly, helped pay for Justice Thomas's pretty lavish lifestyle during his time on the bench with $4 million of unreported gifts. So all those things together in the context of this term make this case, as well as the mifepristone case, that was the abortion pill case, or the case trying to blow up the SEC, all coming out of the, and the Rahimi case about the Second Amendment covering whether it covers people on protective order for domestic violence. Those are all cases, including this one, in which the Supreme Court has sided against what we would think is the right-wing interest, because the Fifth Circuit went so far and extreme in its reasoning that the Supreme Court had to back off and not touch it. But there are other cases that we're still waiting and that have already been decided that show the Supreme Court, when it wants to, reaches out, grabs cases to further its agenda. This is just ways of massaging the coverage, working the refs, and trying to put a face on itself so to protect its legitimacy for when it does want to go full on, all in on their political agenda.
And Mike, when they try to put on that face that, look, we're not as extreme as the Fifth Circuit, wink, wink, we kind of are, but we're not as extreme. Do you think it's notable that they often aren't getting to the merits analysis, that the Supreme Court is usually finding some technical reason, like standing, where they don't have to actually get into the very extreme merits of what the Fifth Circuit's actually saying, and they can distance themselves from the Fifth Circuit, but they also, in a way, the Supreme Court, and this is why I want our viewers to know the broader game plan here, which is what you talk about at court accountability, that the Supreme Court, by not ruling on the merits, but by making these decisions on standing, they could always revisit these issues where they find that there is a plaintiff who has the right standing down the line, and they could tee these cases up in the future. They're just trying to create space, and they see things as part of a kind of broader Federalist Society generational plan, and they realize if they do things too extreme, they're going to prevent some of the broader plans from happening. Do you see it that way?
Yeah, so it's a matter of who's in the driver's seat here. And sometimes standing is an authentic decision that makes, and it's pretty easy to say someone doesn't have standing. And in this case, and the abortion pill case, the Fifth Circuit's view of standing was insane. It was insane. It was so far beyond the pale of anything that the court's, at least power center of Republican appointees, would have ever agreed to in the past. And it was easy for them to say no standing. For this case, though, the pandemic's over. The court, the Biden administration has long since stopped talking with, jawboning, pressuring, whatever you want to call it, the social media companies to police misinformation on the COVID pandemic. It's done. And Justice Barrett's opinion makes a point of saying that. By the time that the lead plaintiff filed suit in this case, the administration had virtually stopped jawboning the social media companies. So this issue isn't likely to come back as a matter in a specific fact pattern. Now, if you look to Justice Alito's dissent, his dissent says the plaintiffs have standing and that on the merits they are correct, and that the administration violated the First Amendment rights. And Alito says that if these claims are true at this level of what the plaintiffs were saying, then this could be the most important First Amendment case in years, and that the majority in shying from the standing doctrine perhaps will come to regret its doing so, because another case could come forward by another administration, say perhaps a future second Trump administration, that does exert massive pressure on a company in order to get it to back down on a matter of policy that affects certain of the company's users. Now, Alito didn't say as much, but it's a thinly veiled attempt for Alito to say, when this comes back again, payback's going to be a bitch, and I'm going to side with, and I'm going to do as you guys said, and there's no standing in what I want will have happened through the Trump administration that I favor, and I'm trying to get back into office. That's ultimately between the lines of Alito's dissent there.
The strange thing about this case to me is that, look, it's not a secret that the White House has press secretary and a communications director and a staff whose job is to jawbone. I mean, is to tussle, is to get into it with the press. Hey, you got that wrong. You better change that headline. You're not saying it accurately. Now, they're not saying to the press this type of stuff that Donald Trump has actually said, where Trump has posted, we're going to shut you down. I'm going to shut down MSNBC, which is MSDNC. I am going to make sure that you don't exist. Those are statements that Trump makes, which I guess if you make those statements and then you combine that with the jawboning, then to me, it rises to the level. There was never any evidence here in the underlying case of any of that conduct. I mean, don't get me wrong. We may not think that the language of people in the White House who were pissed that social media companies were platforming COVID disinformation, like there was the communications director, I think in one of the messages I read, was cursing. Like, how the F can you put this on? You're going to get people effing killed this way. That's different, though, than saying the administration's going to effing shut you down and make sure that Facebook or Twitter effing doesn't exist. You know what I'm like? There's a distinction there that was never, to me, anywhere even close to the line, yet alone crossing the line. And for me, it just looked like things that normally happens from what communications departments do, unless I'm missing something.
You're not missing something, and that's something that Justice Kavanaugh brought up at oral argument, and I believe Chief Justice Roberts also credited. Now, I want to mention something here also. So this case, again, came up from the Fifth Circuit, and before then from a pretty intense Trump judge as well. And that opinion was even more bonkers than the Fifth Circuit's opinion. And I want to just bring attention, because what the judge at the district court said echoed what Alito was talking about in his dissent. I want to read something here, and this is actually from a tweet that I posted in the aftermath of that decision when it came down last year. He wrote, although the COVID-19 pandemic was a terrible tragedy, plaintiffs assert that it is still not a reason to lessen civil liberties guaranteed by our Constitution. If human nature and history teaches anything, this is a quote from another Supreme Court decision, it is that civil liberties face grave risks when governments proclaim indefinite states of emergency. That's a Gorsuch dissent from a COVID case. Back to the district judge here. The grave risk here is arguably the most massive attack against free speech in United States history. Alito echoed some of that today, but I want to just draw your attention to something. This is something that I noticed as well. A through line in the COVID suits in this is this paranoia that Democratic leaders wanted a never-ending pandemic as an excuse to suppress the opposition's fundamental American liberties, when what was actually going on was an attempt to end the pandemic and get back to normal ASAP. And guess what? We got back to normal. The pandemic ended via an administration that was taking the risk seriously and disinformation seriously, and not peddling disinformation or aiding it and taking the risk of the pandemic not seriously. And now we are here sitting before everyone watching in a country where we're not wearing masks anymore, where we're not socially distancing anymore, where we now have gotten rid of the pandemic and face other misinformation risks, like election misinformation risks, that will probably come up now will come up as this campaign season gets swinging. That we'll probably see some of those things in court as well. But we just need to recognize that all this talk about liberty, perpetual denial of liberty, because Democratic governors during the Trump administration and President Biden during his administration were trying to combat misinformation. This is projection. This is coming from people who do want to enact a minoritarian rule over what we, the people, a majority of this country, want, using every lever of the Constitution that permits it. The Senate malapportionment, extreme partisan gerrymandering because of the anti-democratic Supreme Court structure, the Electoral College. to obtain power and then hold on to power in perpetuity. That's not what was going on with the Biden administration when it was jawboning elected officials. And this is the two ways that the sides are seeing this case. One side sees it as, again, a way to make sure disinformation wasn't spilled out and that the plaintiffs in this case did not have standing that perhaps the social media companies would have if they objected to being jawboned. And the other side saying, pretty much projecting its own anti-democratic will onto those who were trying to make sure that misinformation didn't spread. This is what's going on between the lines in these cases, and it's not pretty.
Mike Sachs from Court Accountability, now a law and politics correspondent specializing in helping us break down some of these Supreme Court decisions as well. Mike Sachs, thank you for joining the MeidasTouch Network. We're proud to have you as a new correspondent here, and thanks for taking the time to talk to us about this decision.
My pleasure, Ben.
Hit subscribe. Let's get to 3 million subscribers and have a wonderful day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.